Wayne Hartman versus Cecilia Hartman. Actually, on the record, Wayne Hartman versus Cecilia Hartman. Actually, hold on a moment. On the record, Wayne Hartman versus Cecilia Hartman has 51 Adele. Record, Wayne Hartman versus Cecilia Hartman has 51 Adele 631288. Parties back in. Patrick is present. Let's start the parties back in.
Do you solemnly state the testimony you'll give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
At the last hearing, I was given 2 hours. At the last hearing, directly, I was given 2 hours for testimony on direct that as the issue of child custody visitation completed. That 2 hours was to Mr. completed. Mr. Hartman, so we're turning to Mr. Kilpatrick to start your testimony on the issue.
Objection, Your Honor.
of child
I
custody
wasn't completed on.
Yes, very well.
Objection, Your Honor. I wasn't completed on.
It's been giving you 2 hours to use.
2 hours for what?
The 2 hours I used up.
2 hours for what?
To present your testimony.
I didn't rest my case. I didn't rest my
Or
case.
whoever's ever testimony you felt was.
I didn't rest my case. I didn't rest my case.
We set a time limit. I had to set a time limit.
You set a time limit. There can't be a time. You can't set a time limit on. You set a time limit. There can't be a time. You can't set a time limit on.
Actually, I can.
I object to that on direct.
On direct, I certainly can.
I object to that on the record.
Yes, call Cecilia
Once so
Hartman.
noted. Mr. Kilpatrick,
Yes, call Cecilia Hartman, please.
ma'am, come to the stand. To the stand.
Your Honor, I'd like to say something before we get. Your Honor, I'd like to say something before we get up on the record. Begin your. There's things that need to be cleared up on the record. This case needs to be brought that this case needs to be, you know, that's going on. Brought to attention to for the whole thing about that's going on. You know, like I said, the whole thing about. I'm objecting to that. My main resting. I didn't finish my. I'm objecting to that. This case, and because I didn't finish my evidence. I didn't get to my case. I didn't get to present any evidence. I didn't get to. That's all due violations of due process. That's all due violations of due process right there. I didn't. There was no discovery. For a lot of things that's been going on, evidentiary hearing for a lot of things that's been going on, and I didn't even none of that even happened.
Mr. Hartman, Mr. going to let you, Mr. Hartman, make that record. We'll note that I'm going to let you make that record. We'll note that you're objecting the right to file to the proceeding.
No, Your Honor, I object again. No, Your Honor, I object again. No. Then we need to continue with. And you can't. No. Okay. Well, then we need to continue with evidentiary hearing because I want. There's other. I need to find an evidentiary hearing because there's other things that are going on that need to be brought legally. That to attention that been done illegally.
Mr. Hartman, Mr. Kilpatrick, is that a request for continuance? Is this
Thank you.
fine?
Tell us your full name.
Mr. Kilpatrick, please begin your.
Thank you. Could you tell us your full name? And what do you understand the current custody
Cecilia
visitation?
Fernandez.
And what do you understand the current custody visitation first to be?
Physical with me and all for all the children.
And what is Mr. Hartman's visitation schedule as you understand it? And what is Mr. Hartman's visitation schedule as you understand it?
Objection, Your Honor. I'm not on supervised visits. That's not on the record. Objection, Your Honor. I'm not on supervised visits. That's not on the record. Temporary orders. Never had a hearing for that. Show me where they were. Those are temporary orders, and those need to be temporary. Show me where they were in the orders, and those weren't temporary.
You'll be able to ask her questions about that. It's your turn to ask.
What's that?
You'll be
Well, I'm
able to
objecting
ask
to her
her questions.
testimony because she's saying that that's what it is, and that's. Well, I'm objecting to her testimony because she's saying that that's what it is, and that's visitation schedule. That's not what it is. That's not my visitation schedule.
That's not a legal objection.
The question is, when you make an objection, does it come into evidence or not? She's entitled to testify as to what she believes the visitation schedule to be. You will have the right to cross-examine
When
her.
did the supervised visitation orders, and when did the supervised visitation orders, and when were they implemented by Honorable Susan Gill, former bench officer Honorable Susan Gill?
When, the results were read to our, toxicology reports, I believe. December 5th,
Since that time, has the department ever cited any visitation? Since that time, has the department ever cited any visitation?
No.
What are the current names and ages of your children?
Hartman Jr., Dwayne Hartman Jr., he's Daniel 1 now. Daniel Hartman, he will be Deanna 18 next month. And Deanna
And
Hartman,
you believe your
she'll be
children
16.
are old enough to, and you believe your children are old enough to decide for themselves what their visitation should be? Obviously, the 21-year-old is aged out. Your other son will be aged out. Your daughter, you believe that she's old enough to understand about contact and to exercise just her own discretion about what contact, if any, she would, and you prefer supervised visitation should remain in effect?
Yes.
And do you believe the supervised visitation should remain in effect?
Yes.
Has Mr. Hartman ever paid any child support?
Yes. No.
Has Mr. Hartman ever paid any child support? Current orders continue.
No.
And your request that the current orders continue.
Under the current orders.
Correct.
Current orders are joint legal, so
Under the
physical
current
to
orders.
mothers, I understand. Current orders are joint legal, so physical to mothers, I understand. And supervised
Objection.
exercise father through my
Objection.
exercise for
Making, that's not
nearly.
factual. Objection. That's not making evidence. That's not
What do you believe the current
factual.
orders
That's
are?
not 50-50. That's not in evidence.
What do you believe the current orders are?
It's 50-50, week on, week off. That was given
And
in
what date was that
2007,
given?
16. That was given in 2007, 16. No.
Was there an order given in
2018.
2018? So
No.
what was that order?
2018. Temporary order.
2018. So
Based on the ex
what
parte.
was that order?
Temporary order.
Okay, it's your turn.
Based on the ex parte. Okay.
It's your turn to cross-examine.
So you believe that the orders I should have supervised this? So you believe that the orders I should have supervised this still? That's what you believe? Based and what do you base that on?
Based on your current behavior that you, based on your current behavior that you and your exercised in here, and your lack of communication.
So we had 50-50. In 2015 when I filed. So we had 50-50. In 2015 when I filed. Where were the kids staying at in 2015 when I filed for divorce? Where were the kids staying at in 2015 when I filed for divorce?
It's your role.
No, it's not really.
Overruled. Go ahead and answer the question.
In 15,
Go ahead and
they
answer the
were, in 15, they were. Either with you or with me. Well, it was either with you or with me until it wasn't a week on, week off came in effect. We didn't have a schedule. It wasn't a.
So we were sharing custody?
We didn't have a schedule.
So we were sharing custody? After I filed, you hired an attorney, right? After I filed, you hired an attorney, right? And after you were served? When you hired the attorney,
Right.
you filed for when you hired the attorney, you filed for a custody change, right? You filed for a ex parte? And what was the result of that ex parte? What was the result of that ex parte?
I don't recall.
Okay.
I don't.
Do you recall, you were with, do you recall, you were with Ludi Thompson, you were with, and you were with Ludi Thompson, right? In the ex parte?
Right.
It's irrelevant.
And is that who represented you in the ex parte?
It's irrelevant.
Sustained.
It's yours.
It doesn't really matter who represented her. Next sustained.
It matters in the fact that this is a pattern of
Next
direct
question.
abuse. It matters in the fact that this is a pattern of direct abuse of court. He's been doing this since 2015. Abuse right here. This is what he's been doing this since 2015, since I filed.
Whether or not you should. That doesn't tend to prove whether or not. Next question. You should get
I had custody already,
or
and you know it's
next
been
question.
attacked. I had custody already, and you know it's been no evidence, no taken from me based on no evidence, just allegations.
Then ask them.
Nothing's ever been proven.
Questions for her.
Okay. Yes.
Then
So.
ask them.
Okay. So why did you hire Mr. Kilpatrick? Why did you hire Mr. Kilpatrick?
It's irrelevant.
Go ahead. I'm going to allow it, Mr. Kilpatrick. Go ahead.
Just wanted to switch lawyers.
Immediately, I mean,
Wanted to
right
switch
after,
lawyers.
I mean, you just hired Ludi Thompson, Immediately, right? I mean, right after, I mean, you just hired for your ex parte, right? It was Mr. He did the paperwork for your ex parte, right? Or his associate walked in there. Mr. Kilpatrick was the one that walked in there, right? Or his associate walked in there and was the one that presented the paperwork, right?
Switch lawyers.
So you just switched lawyers. Was it no
Switch
particular
lawyers.
reason? Just switched lawyers.
Recall.
No
I
wouldn't be the fact
don't
that Ludi Thompson already had.
recall.
It wouldn't be the fact that Ludi Thompson already had. He stated that he wasn't going to. It wasn't an emergency, was it?
What Mr. Thompson
Yeah.
said or did not say is privileged.
It was
What
privileged.
Mr. Thompson
Yeah.
said or did not say is privileged.
It was privileged and hearsay.
It's in his affidavit, so
Sustain the objection.
that's filed with the court. It's in his affidavit, so
Yeah, just because it's an
That's
affidavit
filed with the
doesn't
court.
change the character of, yeah, just because it's an affidavit doesn't change the character of it being in testimony as hearsay. Next question.
So
please.
do you remember the result of the ex parte? So do you remember the result of the ex parte? And that day. Okay. After that, what do you remember? What the visitation schedule was? After that, what do you remember? What the visitation schedule was after that?
I think it, I think it was visits as well. I think it was supervised visits as well. If I'm
So
not mistaken.
you were served papers in 2015 for a divorce. You were served papers and in 2015 for a divorce. On that paperwork, and it was for 50. I filed on that paperwork. Is that correct? It was for 50. I filed for 50-50 custody. Is that correct?
We believe so.
Okay. And was there a reason why you wanted to change it up? And was there a reason why you wanted to change it up?
Your, tone, demeanor, and your, children, demeanor.
My
I
June.
felt it was best for them.
My
I
June.
felt it was best for them to.
You felt it was best for them.
Majority of time.
Well, at the soccer part, the evening that the cops were called. At the soccer part, the evening that the cops were called. What was the result of that? It's relevant when they came out to the soccer park indoors. It's relevant to the fact.
Foundation. Well, there's, I'm going to sustain an objection.
What's the
Foundation
time
is
problem?
fine. I have no idea when an objection.
What's the time problem?
I have no idea when it is. You just brought up something. I don't, Mr. Patrick just objected to relevance.
2015,
I don't know when it
we
occurred.
were at
so-
an event. 2015, we were at an event, an indoor soccer event for Daniel. And the police were called out. Do you remember this? It's
It's
relevant.
irrelevant, Your Honor, 6 years ago.
It's relevant.
Under, I'm going to ask for an offer approved, in other words, I'm going to ask for an offer approved, in other words, what?
It lists the fact that that night, the custody. It lists the fact that that night, the kids, the custody, the cops allowed the kids to come home with me of how she acted because of her behavior, which prompted her how she acted out and hire an attorney, which prompted her to run out and hire an attorney and file an ex parte.
The objection. Next question. We're going to, I'm going to sustain the objection. Next question, please.
So after the ex parte, did you speak at? So after the ex parte, did you speak at the ex parte in 2015?
It's irrelevant.
On the stand.
To the judge. Did you speak at the ex parte to the judge? Did you speak at the ex parte about what to the judge? About what was going on? So did your representative, did he mention to the court that? Did your representative, did he mention to the court that there was a lodge, we had a court date filed already? Child custody and dissolution?
I'm not sure.
Okay. You don't think that would be relevant? I mean, if you're filing an emergency, the kids are in danger, yet the judge wasn't aware that there's already a court date set for this matter to be heard, which your own lawyer even said in his paperwork, he understands that instead of confusing the court, we can all take care of this matter all at once on the date that's already set by Mr. Hartman. So it was already in the books, You don't think that was relevant to tell Judge Schuett that?
Objection. That's one, it's not a question, it's completely unentitled.
Sustained.
Did you have any concerns by having the kids took from me then in 2015? Did you care that they were took?
Argument.
Sustained.
Were you just mad?
Argumentative.
And over, if you can answer the question.
Was I mad?
Were you mad? Is that why you filed the ex parte?
No, I was concerned for the kids.
But you did get the summons and the paperwork. My paperwork, it clearly stated in my paperwork 50-50, and there was nothing negative about, anything going on. So what prompted that to walk in there and do that?
Question's unintelligible.
What prompted you to file for an ex parte?
That's been asked and answered several times now. She said she's had concern about the safety of the children.
Right. Well,
And so I'm going to ask that you move on from asking questions as to why she filed the ex parte, because she's made it clear she was concerned for the safety of the children.
well, I'm trying to understand her concern because there was nothing prior in our marriage that would prompt a concern. There was no, So I'm just trying to get her mindset of why, at that moment, she would go into it when I was 50-50. There was no just arguing. If you read my paperwork, it's clear. I've never changed my position since 2015. So it's clear. I was saying, hey, 50-50, we ain't working out. Let's, work together. And I'm trying to understand the mindset of why she would run in there. And if you read what she said in there, I'm like Charles Manson. I'm a monster. They put it so crazy, and then all of a sudden it was just like nothing. It was like, I'm gonna kill myself in front of my kids. I'm gonna put a gun to my head.
Do you have any other questions for her?
Yeah, I do.
The next question, please.
Okay, well, what was the result of after the ex parte in 2015 and the supervised visits? What do you remember when that changed again?
I believe it went to, I think then at that point, I don't know when it started, but I know it was week on, week off.
Okay, so we had a hearing, February 6th, for the dissolution, and
What year? What year?
2015.
Go ahead and ask your question.
And you were on the stand. Do you remember being on the stand?
I believe I do.
Okay, and then you were questioned about, the things that you had said regarding the kids and the schedule that we had worked out. How we talked about it and, at the shop. And, you changed your testimony to, and said that you didn't agree with that the way you wanted the schedule to be. Is that right?
I agree with what schedule to be.
You know how we agreed, we understand, you took stand and you said, we had talked about our schedule, working out 50-50, week on, week off. Remember?
And then I agreed, I'm sorry.
And then you said that you didn't agree to that. You weren't in agreement to that. You said that the kids wanted to weigh in on the matter and you didn't feel like they should be able to weigh in on it. You remember that?
I do.
Okay. So you didn't feel like they should be they should have a part in saying, you know, what they wanted, right?
Right.
Do you feel the same way now?
Now, they are older, and I feel as though they could, share their experience there, and they can weigh on their decision.
I just want to be clear as to who we're talking about. You have Dwayne, who was born in '01, so he's over the age of 18.
Correct.
You have Daniel, who was born in '04, February 23rd, 2004, so he's over the age of 18.
He'll be 18
Well,
That's
18 plus 4 is 22. What was his actual birthday?
It's 05.
It's 05. It's not
Daniel is
2000.
05, so he'll
Okay.
be 18 next month.
So that just leaves Deanna.
She
So,
is currently 15.
okay.
She'll be 16 in a few days.
I'm sorry, say that again.
She'll be 16 in a few days.
And she is also here if the court wished to make inquiry of her, or I may call her as a witness in rebuttal.
That's up to you, but I would be interested to hear what her perspective is. I normally don't like putting children on the stand, but under this is a very unique case. So
It is. It's a unique case.
yes, I've never had. Yes, we're going to ask another question.
So in 2015, we had 50-50 after all said and done. It was 50-50 all the way up to 2018, correct?
Correct.
And everything was concluded, and we had mediation 50-50s. We already had agreement. And what we had on the books was a week from the time you filed that ex parte, we had hearing scheduled in a week on remaining issues, right?
I believe so.
Right. It was a week right before the hearing. Again, what prompted you to file that ex parte?
It's not relevant.
Sustained. Next question.
So 50-50 all the way through from 15 to 18. The kids were going to school week on, week off. Was there any problems?
It's not relevant. We're way past that.
Oh, we're not way past it.
Sustained. Next question.
Did you ever call the cops or anything? Did you ever file a police report on any of these ex partes?
It's not relevant.
Yes.
Overruled.
I've called to have I think it's, I'm not exactly sure of the term, a courtesy check, if I'm not mistaken, with the police department. I've called a few times. So you don't answer the door?
I don't?
No.
Are you sure?
So, yeah, you don't answer the door. They're in the hallway. They have to be quiet until the cops leave.
Oh, really?
So,
Okay, that's okay. I don't remember. I remember them coming in my house, and the kids were there.
You're
They'll
not
testify to
asking a
that.
question, sir. You need to ask a
So
question.
I don't know where you got that statement from, but I don't answer the door. I've always answered my door. But you ever file a police report? Has there been a police report filed?
It's not relevant.
Well, it's speculation as to whether or not a police report was filed because she's not familiar with the police system. She doesn't know what was filed or what wasn't because she doesn't work for the police.
She has to work for the police to know how the police system works.
Next
I want to know if you filed a police report. Did you call and report a crime?
I called and asked for the kids to get checked on,
So you called for a welfare check, right?
welfare check.
Right. Have you called any other time for anything else?
And it's vague and ambiguous.
Sustained.
Has there been did we ever have any problems in domestic violence in our relationship?
Yes, you've displayed domestic violence.
What is displayed domestic violence to you?
So you are loud, your tone is louder. When you're yelling, you're in really close proximity of me. You are, you interrupt.
That's domestic violence?
Objection, she has the right to finish her answer.
She does. Finish your answer, ma'am.
You are, you isolate, so the family would not, I just recall always having the excuse that gas was always too expensive, so traveling to the opposite side of town wasn't, you wouldn't let me go sometimes. So controlling.
So when we got married, did you have a credit card?
Not probably.
Because the issue of control.
Okay.
Go and answer the question.
Yes.
Yeah, credit card. Did you have a vehicle to drive?
Yes.
And did we ended up upgrading to you vehicles?
Yes.
Did we fill the tank up every week?
Yes.
And did you work with me at the shop?
Yes.
And prior to working with me, you went to school, correct?
Correct.
So you ended up, you graduated, right?
Yes.
So you went to school while I worked?
Right.
And then after that, you started working at the shop. And what time would you come into the shop to work?
I don't recall. I guess after dropping the kids off, probably 9. About 9.
So it was pretty lenient. I mean, you came in kind of when you got finished in the morning with your errands.
Right.
And did you ever have any problems running out of gas, or did you ever have any problems shopping, or did you kind of do what you wanted in the morning, or?
I don't understand. Do what I want.
Your schedule wise, I mean, you weren't under any. You say you couldn't drive, you couldn't go anywhere, but you had a full tank of gas. You were always going over to your mom's. So when was this that you couldn't go with your parents?
Well, to go visit my parents.
When you couldn't go visit them?
No, you wouldn't allow it.
Are you saying that I had a problem with your parents?
That is not what I said.
Then why wouldn't you be able to go visit your parents?
Because it was too far and gas was expensive, is what I was always told.
Okay. So we had 50-50 with the kids since 2015 all the way to 18, right? Do you remember how many times you filed ex parte between that time period?
No.
A total of 3 times. Do you recall that?
Okay.
And each time there was no police reports, there was no evidence. It was just basically you and Mr. Kilpatrick saying, I'm a monster and the kids need to be away from me. Correct?
Correct.
And what prompted you to do that? Why? I don't understand.
It's asked and answered.
It's a state.
I mean, is there a certain motive that you have? I mean, you don't agree with 50-50 in parenting?
It's asked and answered. It's irrelevant.
It's a state.
Are you saying that I wasn't involved in my kid's life as they grew up?
It's argument.
Sustained.
Is there a reason why you don't have the kids call me or my parents now that you've taken them from me?
Misstates the evidence, misstates the testimony.
It's
The court issued the orders, not this one.
best interest of my kids would be both parents involved. And if one parent did that and cut the other parent out, that's parental alienation. Okay, and that's that. And I haven't heard from my kids because a parent doesn't feel like they should. Hey, call your dad. Hey, call your grandparents. We're in their life every day. And just get cut out and no hearing, no evidence, no nothing.
There's no grandparent visitation orders.
And then say there were.
Issued ex parte orders.
Didn't need them.
Okay, 5-minute break.
You step down this way.
Back on the record, Hartman versus Hartman. Ms. Hartman, if you could resume the stand. I'll remind you that you're still under oath. Next question.
One moment. Are you familiar with the term parental alienation?
No,
Okay. Have you ever heard it before?
just when you mentioned it in court.
Okay. There's certain things that go along with parental alienation, you know, and there's like key factors that are that point out if that's what's going on. You know, one being that the kids are bonded with both parents, and then all of a sudden the kids want to go against one parent. And do you feel that's what has happened with our children? Do you think that when they're going against me for a reason?
Against you for a reason?
Well, you mentioned that how they feel and what they want, and do you feel that they are not wanting to be with me?
One, it's irrelevant. Two of the children have aged out. There's only one minor child left, and she's prepared to testify.
We're gonna hear from her in a moment, so.
Okay, and again, do you feel that the kids are wanting to not be with their father?
Do I feel that they don't want to be with you? I feel as though they do not want to be in your custody, correct?
And you feel that, now do you say anything to them about that? Do you tell them, to anything towards reaching out, or that relationship that, you talk to them about it?
I don't.
You don't. So you don't feel, we went from a marriage where we're together every day, sports, music, school, straight A's, you name it, camping every year, to, okay, we're getting a divorce, and then all of a sudden you're saying that you don't talk to them about being involved with their father anymore, right? Even though they went to work with me, every day we were together. They're with my parents too. And you don't talk to them?
Well, there are so many, that's not even a question.
Okay, the question is, do you not talk to them about the relationship of both parents, you and a relationship with their father?
I leave the door open for them to make that decision. Have a relationship with you.
So you leave it open. It means that, so do you, they're not, they haven't been through anything like this before in their life, correct? They haven't been through anything with court at all, right? The kids have not been involved in anything like this traumatic in their life, have they? In court, they have not been in any involvement, law, court. Have they been in any involvement?
Completely unintelligent.
Mr. Hartman, you have a tendency to raise your voice. I have a duty to make sure witnesses are not badgered. This is my first warning.
Badgered?
The next time you raise your voice at the witness, I'm cutting off cross-examination. I'm sustaining Mr. Kilpatrick's objection. Ask the next question.
Do you feel the kids are qualified to understand the process of divorce?
Yes.
You feel that they're qualified to understand this process?
The process meaning I don't understand what you mean by process.
Like you said, you made a statement that you left the door open for the kids to basically decide on their own, right? If they want to have a relationship with me or not. And you said you're fine with that. And then now you're saying that you feel that they can understand this complex process of divorce, even though they're not even grown, they haven't been in a relationship, or they haven't been in the courts. What would make you think that, from being in a relationship from every day with their father and their mother, all of a sudden now they're not? You're saying that they don't want to call, they don't want to be involved? But where does that come from?
I still don't understand what question you're asking.
I'm trying to get you to explain to me why you think that, because I encourage them to still call you. I would not let them not call you or involve you. I haven't heard a word about school, medical, anything. And you feel like that's fine, right? It's up to them.
He's arguing with her.
No, I'm not arguing. I'm saying that's what you said. You feel like it's up to them. Correct?
I'm overruling the objection. Mr. Patrick, go ahead and answer the question. If you understand it, if you don't understand. Okay.
All right, let's do this then. All right. Your first attorney, Ludi Thompson, filed paperwork for you on the ex parte, correct?
It's irrelevant.
No, it's relevant. It's prove the fact that what it is, what it's going to prove everything that I'm saying. It's going to prove everything I'm saying that's relevant to this case and what's going on. Her statement, her affidavit, everything, and there's prior testimony and transcripts that she's already testified to this court that's our lodge, and that proves what I'm saying.
It's irrelevant.
It's not irrelevant.
I'm going to allow the testimony, and I am giving you 10 more minutes on cross-examination.
Your first attorney filed paperwork for you when you filed for an ex parte in 2015, correct? Can I have the witness look at this document?
Deputy Walker will hand it to her. Specifically, after you show Deputy Walker what you want to reference Mr. Kilpatrick in full.
Declaration there. You recognize that? Those documents? Okay. This is your declaration? Remember this? Okay. You see the bold writing underlined there? It says,
Yes.
the petitioner threatened. Where it starts, it says, the petitioner threatened to kill me. I think it'd be like in 17. So always all right.
Yes.
So, can you read the bold the statement there that's underlined?
Line 17?
Yeah, 17. Where it starts at the petitioner under the underlined bold.
Okay, the petitioner threatened to kill me upon discovering that I had withdrawn some money from our joint bank account shortly after leaving the family home. The petitioner told me that I needed to put the money back into our account immediately or he would find me and shoot me.
All right. So I threatened to kill you, right?
He did.
Okay. And the other bold one that starts on line 8, where it says the petitioner became. You see that?
Yes.
Can you read that?
The petitioner became so upset with me that he put a gun to his head and threatened to take his own life in front of me and our 3 children.
So I threatened to kill you and the children and put a gun in front of my head, in front of my children, right?
No, so I recall. So what happened was line 7, you can see this happened January 1st, 2015. You had gone out for New Year's and you did not come home until the following New Year's Day at 4 in the morning or 6, whatever, 5, I don't know, early in the morning. So you were gone out all night. When you woken up we were upset with each other, and we argued because of how late you came home, and then, I told you, well, you know, I guess the kids didn't realize you were even gone, or we were just arguing, yelling at each other. So you became upset, and you put the gun to your head. The kids were in the living room. So I remember that. I don't know why he put that the children were there.
So that's not true then?
So you did put the gun to your head, and you did threaten to take your life, and you were crying because you had it there in the bedroom. So after this incident, that was when I knew that I needed to leave, because the arguing became more and more. January 6th was the day I left. So tomorrow is exactly 8 years that I left here.
So that statement isn't true then? That wasn't, you said I put the gun in front of my kid, to my head in front of my kids?
In front of the kids? No, the kids were not there, but it was me and you.
Right, okay. Me and you. And then I threatened to kill you, discovering upon that you took money, which
Yes.
I threatened to kill you. Do you remember what day that was when you took the money? When I discovered you took the money?
I believe it was January 6th.
Okay. So, was there any, did you call and report this to the police?
No.
Okay. Why not? It's pretty scary if that, I mean, why didn't you report it?
I don't know. I just didn't.
Has there ever been any other, like I said, did you ever call and report me to the police ever in our marriage?
I didn't.
No? You say here that I was a gambler and you were afraid I was going to gamble our money away. Is that correct?
Correct.
Was our bills paid? Was our bills paid?
Yes.
Your car was paid off?
Yes.
My truck was paid off?
Yes.
My house payment was paid down?
Yes.
There was savings money in the bank account?
Yes.
Yeah.
But depleting.
It was depleting. It wasn't due to the fact that we had our house remodeled?
No, it was due to the fact you were withdrawing money and gambling.
Well, I've got checks to show that we paid Sean Iris to Crown Molding, and we yeah.
And we also, I'm sure you probably pulled receipts from you withdrawing 3,000 to 5,000, 3,000, 1,000 here.
Okay. Well, we did a lot of things to the house. We put brick walls up. We did all that. But you say you want to make it sound like I'm a degenerate gambler, and I was going to blow the money. My credit score was 820. I had no bills. What would make you say this? Is this just a prompt to make me look bad, or why would you say I was a degenerate gambler if we didn't have any financial problems?
Because I felt as though it was spiraling and getting out of control.
Yeah. Okay. So you felt that after this happened, New Year's, I woke up, put a gun in my head. I'm like, yeah, blah, blah.
Yes.
You didn't even hire Ludi Thompson yet, right? It wasn't until after the soccer part. That's when the cops told the kids to come home with me. When you attacked my mom, they let the kids come home with me.
Did not attack you.
Okay, well, yeah, it's in the declaration, and there's pictures there too. But the cops let the kids come home with me, correct?
Yes.
After that night, that's when you went and you hired Ludi Thompson, correct?
I don't recall the date in the chronological order, but
It's stated on here. You know, like you don't feel like it was because of that incident that the cops let the kids come. Were you panicking or something? Did you panic? Is that why you would prompt you to say this?
no. No, the understood, the document that you showed the officers was just a filing. It was not endorsed, so I don't know what prompted the officers to have them go with you, besides you had a court document.
Well, I mean, the kids were staying at the house, the school's, down the street. They already had a court date on file. I mean, what, is that the reason you went and hired Louis Thompson the next week?
None of this is relevant, Your Honor. I've tried to maintain.
Well, I would sustain the objection. One last question.
What's that?
One last question.
About what?
Whatever you want the last question to be.
Objection. You can't limit my cross-examination. I have a lot of things I got to talk about here.
The law, when it comes to cross-examination,
Huh?
is that, and I'm surprised Mr. Kilpatrick hasn't objected to this, is that you
Oh.
can't ask questions beyond the scope of cross-examination. You've gone well beyond the scope of cross-examination, well beyond the scope of direct.
The scope? What is the scope?
Whatever, he asked, Mr. Kilpatrick asked maybe 10 minutes worth of questions. You have been asking questions roughly 45 minutes. You've gone well beyond.
Okay, well, objection, Your Honor, because this stuff, my direct examination of this witness wasn't finished. I haven't been able to even present evidence, and that's why this whole thing is due. And if that's what's going on here, I don't know what, my rights are being violated, correct? Because due process,
I'm not gonna say
discovery.
Mr. Kilpatrick, you don't have any other questions for her,
I do
correct?
not.
I have plenty of questions.
Ma'am, go ahead and have a seat by your turn.
Okay, objection. Then this is just not been right. Then you're not. Then you know what? This is
Next.
you're losing your jurisdiction, subject matter on this issue. Then that's what you're doing because you're not. This is right. You're violating my rights right now. I don't know if you have something else. What's going on here? But I'm not finished with this witness.
You are now.
This is my case. I'm the petitioner. It's my scope for one.
It is not your scope.
How is it not my scope when it's my witness?
Because we were on his case in chief. Next witness, Mr. Kilpatrick.
Yes, Deanna Hartman, she's.
That's an objection. Then this is not right. This is not right, Mr. Webster. This is not right. Okay, this is violation of my rights right here.
And you will be able to discuss any of this with the 5th District. if you-
Oh, I will. Okay, so that's how you're gonna do it then. Okay, all right. Okay, this is a big scheme. Then this is a scheme. Okay. Yeah, I should withdraw my petition then for this. I'm the petitioner in this matter, right? I can withdraw my petition for this matter then, right?
No.
Yeah, I can.
Response filed.
Huh?
There was a response filed. We passed it.
No, because this has been a mistrial, and there's on the scope of things, the mistrial wasn't even correct.
Right, this one. So before you sit down, if you look right over there to your right,
Do you solemnly state that the testimony you give in this hearing will be the truth, the whole truth,
Your witness, Mr. Kilpatrick.
Yes, would you tell us your name, please?
Deanna Hartman.
And Ms. Hartman, how old are you?
I'm 15, about to be 16.
When do you turn 16?
January 25th.
So just here in a few weeks. You're aware of these unfortunate proceedings between your parents?
Yes.
When was the last time you had any contact with your father?
Like over text or in person?
In person?
3 years.
And you understand that you have a say in what contact with your mom and your dad you have in light of your age?
Yes.
And are you afraid of your father?
No.
Do you want to have contact with your father?
But like.
Face to face, to go on visits, spend the weekend or something like that?
Yeah, I would like to spend the weekend.
And you think you can work that out with him, when would be a good time and all that?
Yeah.
Sure, I have nothing else.
Do you have any questions for her?
Yes. How come you haven't called us? Is that what you're supposed to call your parents or your grandparents? That's how I was raised, right? It's not the other way around. How come you haven't called your grandparents?
They don't want to talk to me.
They don't? I think they do.
Every time that I reach out, or they reach out to me, and I respond, I just receive negative.
They're hurt. They're hurting. You know that, right?
So am I.
I know. I know. You were with Oma and Opa every day, correct? Every day.
Hmm?
They picked you up from school almost every day, right?
Right.
From kindergarten on up.
Grandparent visitation is irrelevant.
It's
Sustained.
you were in dance because of Opa, right? The boys were up with us shop every day, huh?
Right.
So I don't understand why. I understand it's hard, but you have to understand that, you know, they love you, and you're a big part of their life. So
Grandparent visitation is not completely.
Sustained.
you know, it's like you said, you're old enough to decide you can do this and that. He wasn't talking like that before. He's saying that now, but you know, you can. There's things that you can do, you know, and decide. I know that you guys have been put under this bubble, and and creating this atmosphere, but you guys can have a voice. You know that, right?
Right.
So, has everything been going well with you?
Yes.
How's your health?
It's fine.
Have you been to the doctor?
Yes.
For what?
I went for a physical for soccer.
Do you have any problems?
No.
No cardiologist problems?
No.
You didn't have to go see a cardiologist?
Oh, yes, I did.
What was that for?
It was for an EKG.
I know, but was there a problem?
When I went and had my physical, I had a slow heartbeat. So I had to get an EKG, but he said it's just an athlete's heart.
So it's normal?
Mhm.
You didn't feel like maybe I should have been included in that? That you went to have to see a heart doctor?
It was nothing serious.
Well, maybe not to you, but if I hear something like that, I'm concerned.
He's arguing with her, Judge.
I'm not arguing with my daughter.
That's how I'm perceiving it. Next question.
You know, it's just like parents are going to be concerned about the health of their kids. So, not arguing with my children about their heart problems or their murmurs or whatever. I don't know how you perceive that.
Next question.
Do you, you have animals at the house, right?
Yes.
You still remember them, right?
Yes.
How long has it been?
3 years.
Mm. So it just plucked you right out. Stopped it, right? Boop. My life with Dad, right?
It's unintelligible, sir.
Sustained.
Do you miss me?
Yes.
How's your grades in school?
Good.
Boys?
It's irrelevant.
Yeah, I'm not going to answer that question in court. Next
Well,
question.
it's the only time I get to talk to her. So I'm asking her, my daughter, because I don't get this information I don't get, Your Honor. This is sad. This is what's sad about this proceeding. You don't get it. You guys don't get it.
He needs to be admonished.
Yeah, this is crap, man.
He's threatening all of us.
I'm not threatening anything. You guys are hurting me. You pluck a child out of my life and then you don't give me anything, and you say so. This is sad. I object.
He's becoming dangerous.
Oh, dangerous. I mean, I'm hurt to see my daughter grow up without me because someone made an allegation about me. That's hurtful. I don't know what you think. That's not normal. I'm the petitioner. I asked for 50-50.
Sir, you need to seriously bring it down a notch. Do you understand?
Yeah,
Okay. Thank you.
this isn't right though. You know, I mean,
And having seen what you just saw, do you have any concerns about visiting your father?
I just think that's how my dad is when I saw him in the book. I just don't think anything has changed.
I have a last question to ask.
Okay.
Did you witness a fight between your father and other family members? A fist fight? Remember when that happened?
This fight,
Yes, or physical pushing contest, yelling?
yes.
When did that happen, do you remember?
Can you like elaborate on this fight a little bit?
this is objection. She doesn't know what he's talking about, and they're going to put it in her head. Objection.
Okay, lack of foundation, sustained
Did you see-
disability foundation.
Yeah, did you witness your father put his hands around the throat of his current significant?
Objection.
Yes.
And when did that happen?
I don't know the date.
Just tell us what you saw.
It was at like 1 in the morning, and I had woken up and to get some fighting in the living room. So I went, and my dad, well, his girlfriend was sitting on the couch, and my dad was standing up in front of her, yelling at her. I think about putting on her phone. He had her phone, and so I went to. It started getting intense, so I woke up my oldest brother, and I was like, hey, I think you need to go out there. And so we went out there, and he had his hands around her. So right below,
Around where?
like,
On her throat, like he was
yeah.
choking her?
yeah. And so my brother just told him to take his hands off of him, and it started another fight.
Thank you. I have no other questions. We're actually excused.
On the issue of the fight only, you can ask questions.
Are you afraid of me, Deanna?
No.
No further questions?
Okay. This is witness free to go.
No other witnesses from the respondent on custody visitation.
This way, man.
Okay. Any other custody visitation issues? Moving on to property, if any, are there any property issues?
There
Yes.
is, there's the house and the box credits associated with the house, it's fair market value.
Separate property.
Okay. Starting with the house.
I had a property on Sandra Drive, 1001 Sandra Drive. That was my separate property. The paperwork was it's going to be, the deed and everything is with the title company.
When did you get married?
2001
When was the house purchased?
and 2000.
Mr. Kilpatrick, was that accurate?
The house, he did have a home before they were married, he placed my client's name on the residence. It was
No, I didn't.
Mr. Kilpatrick.
It was subsequently sold, the proceeds of that house went into the current form of family residence. And her name is on the deed, it's presumptively community property. We believe that the house is worth about $350,000, he currently owes $51,064.
He's mistaking properties. That's not the wrong property he's talking about.
I'm gonna let, getting ahead of myself, Mr. Kilpatrick. I'm gonna let him testify. He can,
That's fine.
If he can, I apologize.
Yeah, he actually made.
We're getting ahead of myself.
No worries, Judge.
Go ahead.
The property I'm talking to separate is 1001 Sandra Drive. The property he was referring to is on Seeger Court. That's the one she's on the deed. The house, 1001 Sandra Drive, I bought as a single man, and she was never placed on the title, never was on the deed. And I sold that property to purchase this property, the property that we were when we got married. So
So do you currently live, I'm confused, do you currently live on the Sandra Drive property?
no, that's the property I sold. That's my separate property.
Okay, so when did you sell that separate when did you sell Sandra Drive?
2004.
Okay, and what house, if any, did you buy during marriage?
9417 Seeger Court.
Cedar?
Seeger, Seager.
Do you currently live in that house?
Yes.
Is it your contention that that house is the Cedar Point, or is your separate property?
No. Sandra. I sold it to put the money down on Seeger.
Now, is the title held in the Cedar Port property?
The title on Seeger is held in both our names.
Do you, Sandra Drive, you sold that in 2004?
Right. And I put the total money, I put the 110 that I made from Sandra, I put it on Seeger.
During the marriage, you bought Sandra Drive prior to marriage, roughly a year. Is that accurate?
Yes.
During that time period, how did you pay for the mortgage on that house?
I had I had a checking account, I just paid it with a check.
From
my checking account.
Employment earned
Yeah.
during marriage?
Employment before I was married.
When you have a house that's bought before marriage and it's paid down with community property funds, it creates what's known as a Moore Marsden issue. A Moore Marsden issue indicates that there's a community property interest in that property. Are you familiar with how much community property interest is or was at the time of the sale of the Sandra Drive property?
There was there was a period, like I said, there was a few months there where that she probably would be, as far as community property goes. I mean, the payment was so low on that house, it was still as low as it was on this one. So there was a short period of time, there was a few months there where it would have been the community.
Well, it would have been 2001, 2002, 2003.
No, it would have been 2000 for Sandra. We're talking about Sandra, right?
I am talking about Sandra. You bought it just before marriage,
All right.
and then you paid down the mortgage using community property funds, and you sold it in 2004, correct?
All right. Well, she wasn't working. I mean, it was coming out of my account.
Money earned during the marriage by either party is considered community property funds.
All right. It wasn't commingled or anything like that.
It's any marriage, it's just the way money earned during marriage
Okay.
is community property. Mr. Kilpatrick, have you done a Moore Marsden analysis on the Sandra property?
No, it's not, that's not my burden, it's his burden to do the Moore Marsden analysis so that he can determine whether or not there's a potential 2640 claim into a separate property interest in the Seeger Court property. That has not been done, and therefore, it's my view, there's no separate property interest traceable, and it's a direct tracing method only with documents as required by the code. None have been provided. He's not provided the Moore Marsden calculation. He's not provided the 2640 calculation. Therefore, Seeger property, in my view, is 100% community property, and it's worth, there's about $298,000 worth of equity in it, and there's watch charges of probably about $90,000. So it's our request to sell the property, split the proceeds, reimburse her for her watch credits, and that's the end of it.
Okay.
No objection, Your Honor.
Go ahead.
It was presented. Mr. Kennedy presented it. There, he tried to throw Watts charges without the without the credits of maintaining it. You know, without, you have to have one with the other. You know, he's incorrect as far as Morris Marsden goes. It's just, you know, he's going on off of just numbers on his head. He's not going off anything factual. You know,
That's not true, Your Honor. I understand the Moore Marsden calculation. I understand Family Code Section 2640. I've been a family law specialist for 40 years. And you can laugh at me if you want to, sir. It's okay.
the documents have been submitted direct to prove that have separate property. I have all the documents have been lodged and they were subpoenaed from the escrow company showing that I was a single man, I was own chief and signed paperwork. There's documents there that are notarized saying that it was my separate property. She has no tax interest in it. The documents are there. He's saying they're not there. They are there and they were lodged with the court.
Okay, it's now 2:48. I'm going to take an early 15-minute recess.
All right, thank you.
I do. You can come in, Dad. This is bullshit, man.
Get through it. Get through it. Do the best you
I
can.
can't.
You are. You are doing the best you can. You're doing as good a job as anyone in your position can do.
I'm telling you, I couldn't stand in your position where you're at today.
You're doing it, and you can walk away, win, lose, draw with your head high.
He almost walked off a while ago. It was Dave where he was getting, Dave was telling him if he got raped, if he was started acting her again, he was gonna throw him out. When he was just asking questions. But he started to turn into that so that he would get frustrated.
Yeah, sure, they're gonna, you know, then try to push your buttons all the time. Don't let them do it with it.
You can do it.
No, you can't. It's amazing what you're capable of. Put your mind to it. You got all the facts and figures and forms right there in front of you. Take your time, look at them, read them. Don't read.
He's always forcing me to sell the house. So,
Why should you have to sell your house?
right.
Yours now?
Yeah.
Say no.
She's not entitled to the home.
That's title of that now.
And you could give her the property, right? Like, if
What?
you wanna sell your house, you could give her.
He's already got enough money
Right,
in the bank
so
to
you
pay
say-
for
Yeah.
whatever she's entitled to.
So he just said,
That's why he's in there though, and you need to speak.
I'm gonna come in there.
can
You
he?
can just say something if something ain't right, man.
I would have stood up like 6 times in there. You can do it, babe.
Where'd the kids go? Did they say anything to you?
Yeah. Junior came out and Junior said something about get dinner for everybody. I said, well, I said, don't do anything on my behalf because you can't do that hard. These holidays are for us. You have no idea. I said that you'll grow up and you will. Right now you don't.
Say something.
That's very true.
But you did hear me when I made it a point for you to hear me.
What'd you say?
When I said, no questions, no questions, no, because I'm on the outside looking in. And I'm there to give you that cue.
I wanted to talk to you.
I understand that, but she said she wanted to talk to you. She wanted to see you. She should just left it at that. No, man. The core. I'm not talking about the core.
2:30, I had my move my truck.
Got plenty of places now.
Yeah. They cleared the calendar for today.
Yeah. But you know what I'm saying? She'd already said. And so when I say out there, it's because I'm looking, I can see what's going on. You know? How long is this break?
15 minutes.
Your stomach's upset?
I didn't sleep last night. Feeling like I wanted to throw up or something. I didn't even eat this morning. Just came down with something.
Probably.
Worked on Don Clark's car all day yesterday. I didn't get out home till 7 o'clock last night. When he dropped off his wife's car, we worked on him.
What's wrong with them?
Huh?
What's wrong with them?
Oh, his fuel filter was plugged out, the shocks were shot on it. $515 to repair.
Oh, well, that's good, but it's just hard. It's just work, just coming home late and being tired.
I charged him $100 an hour.
Sure, it's a lot. I mean, I don't really know how to do those things, but I'm pretty sure it's pretty hard work,
I'm not gonna do that for nothing, shoot.
right? Why is it 15-minute break?
Taking second section, trying to get fake numbers.
Have a deed pulled up real quick. What's her name on it? Just going through this. Man, they jumped right out of that. They jumped right out of that child custody right into the home. Like, cut. Okay, the house was instantly like they stopped it right then and said no more. What were the orders? I don't even think they gave a ruling on that one. Did they? I didn't hear one. They said it was done. Yeah, I didn't hear anything. They said, okay, that's it for the visitation. Now we'll move on to the assets or whatever, the remaining. Did you take those one cards out of there that I put in there last night?
Mm-hmm.
Did you look at them today? I thought you were getting stuff ready for today. You gotta unfreeze yourself. You gotta push yourself to unfreeze, babe. You can. Yes, you can. Don't say I can't do nothing. You've done something. Quit saying that. Well, when I get to you now, you gotta stay on point right now. What are you doing? Don't let yourself get down. You're gonna be down in there if you let yourself get down in here. Out here. You don't want to give up right now. You made it this far. So no matter what, whatever the judge says goes. So no matter what, whatever the judge says, like, goes.
Yeah, that's whatever decide to.
That's why you just like annoy me. Like next. To put me on time limit. You can't put time limit on cross examination. I specifically looked it up. Can't do that. Look at your idea. That can go on for hours like that. I did.
He did tell him. He did.
I did tell him
Those
that.
exact words.
He said, "Oh, you're done."
He said, no, you're done. Because he said, you've been going on for 45 minutes now, Mr. Kirkpatrick, you sit there and not, and he allowed you to do that. I didn't know it was just a choice.
Right.
To allow you to talk for 45 minutes.
He's making up things that Kirkpatrick should have done.
He should have cut you off by now, but he gave you the extra time.
Yeah.
Well, he did? Thought you did.
Oh, and I go, I didn't even put my thing to rest. You know?
He's like, I have a lot more questions. He's like, no, you're done. Do you want me to go move your truck for you?
Huh?
Do you want me to go move your truck for you? You could go in there as soon as well. I'll just move it a little closer.
It's like right in front like that. This next one.
Will this stay current?
Yes, yeah, she's gonna have total discretion over what she wants to do. She's gonna have to see what she wants to do. She can go lunch with him, it's totally up to her.
She have to come back and stand to clarify.
I don't think so. It's the neighbor, it's basically something. She's a sweet cat too. I mean, she really looks just like you. You guys could be twins. And so she's play soccer.
Back on the record, Hartman versus Hartman. Parties are as previously noted. We are having you testify about the two properties, documents that were put into evidence prior to this aren't in evidence now because there was a mistrial called. So that means we start from scratch. Do you have documents you want to put into evidence at this
Yes, Your
time?
Honor. That's the grant deed for Sandra.
You want to take it all at once, Your Honor, or bit by bit?
Oh, let's bit by bit.
Okay.
That's one, correct.
Petitioner's Exhibit 1, marked identification.
Mr. Kilpatrick, any objection to one?
No, Your Honor, it's a certified copy.
One is in evidence.
I'm looking for a document where she had signed it over. And the court should have the paperwork that Mr. Kennedy filed, right?
And the clerk, do we still have possible we don't, because there was,
Okay.
Well, it wouldn't matter anyway, once the mistrial is declared, he has to reintroduce every exhibit that he wishes to introduce, authentically lay the appropriate foundation.
I don't disagree with that, I'm just wondering if we have the physical copies available for that. objections to 2?
No, Your Honor, it's a certified fact.
We're having the exhibits from last time brought over, if they exist still. Again, it doesn't mean that they're evidence, it just means that they'll be available.
Understood, Judge.
Petition exhibits 3, 4, and 5, marked for identification.
Exhibit number 3. Up in the upper left, it says disbursement history. Mr. Kirkpatrick?
We object to that. It's not a deed, it's not an instrument of title. It appears to be something from an escrow company. It lacks foundation, it's hearsay.
Do you have anyone from
It's-
escrow company to lay foundation as to this
Well,
document?
the subpoena that, where the documents were lodged, it's from the escrow company. It's in that set of documents that's been lodged. And that's just a breakdown from the escrow that showed, there was also the receipt from them too, showing the check and the check number from the separate. That's just giving you the breakdown of it, so it's easier to look at. I
They're
mean,
inadmissible.
When you say subpoena, describe, when were they subpoenaed in? When were they subpoenaed?
They were subpoenaed in, I want to say July of 2018.
Yep, perhaps for the first trial, and then after the mistrial, that subpoena is no longer valid. For this case, it would have to be resubpoenaed, and therefore this lacks foundation. It's a hearsay document, it's inadmissible.
Okay, let's move on to the next one, prior rule on that. Receipt for deposit.
Same objection, it's a hearsay document, lacks foundation.
That's receipt for the deposit. That's from the escrow company, also showing the check and the check number from the separate property where it came from.
Buyer's final settlement statement.
As a final settlement statement, same thing as a hearsay document, lacks foundation, absent a custodian of records through a records deposition or a custodian of records testifying in court. The foundation cannot be laid by Mr. Hart.
Or subpoena into court. Did you subpoena?
Right.
this trial?
It's regular business course. That's how First American does it. I mean, that's a breakdown of how they do their records. I mean, it just shows.
Okay.
Evidence Code Section 1271 is quite clear on how these documents should be admitted so that they're properly admitted.
My concern is the 1531, I don't know if I'm saying that correctly, there was a stipulation for the copying and not disturb the chain of custody.
That did not happen in this case.
What's that?
Was there an agreement after they were subpoenaed in, brought by subpoena, did you enter into an agreement, or your attorney enter into an agreement that the chain of custody would not be broken once?
They didn't. They did.
What date was that?
That was on. I want to say July of 2018. The hearing in 2018.
July I don't specifically recall that stipulation, and assuming there even was one, it's no longer valid for this case in light of the mistrial, because mistrial, law of mistrial is clear. Everything that occurred during that trial is vacated, and we start over. And that subpoena would have to be redone, and a new stipulation entered into. That has not happened.
And that would be including visitation also then, right?
We're,
Everything.
that's why I'm trying to see what the wording of the stipulation is, Mr. Kilpatrick. That's why I'm trying to, but I've not seen the July. Let me look at the computer, let me look at the file through a different computer program. There was a hearing in June and a hearing in August. I'll look at the first one in June first. I'm looking at June 2018. There does not appear to be an agreement on that date for the issue of chain of custody.
It was around the time the subpoena was done, so I mean Gil was still on the bench.
Well, she's still on the bench. She's just over in June.
Well, I mean, she was on this case.
And there does not appear to be a stipulation in that date. On August 20th, I'll back up one more month to May. Okay, and I've looked at 3 months around the time period, and I don't see any stipulations.
I can find it for you. It's I remember when candidate when they lodged it and they agreed on it, and I think he mentioned something about as long as it's followed, it's fine. He said something about as long as it's followed, if it's no certain, I'm fine with it. And they made that agreement. I have it on my notes too. I just
I'll let you take a look at your notes,
Okay.
and I'll see if it's in
all right.
order.
Okay, there's also another document here. There's another document for
We're not gonna look at the other documents. Well, actually, we will look at that one, because I'm, get any documents you think that are admissible because of an agreement between the parties, and I wanna deal with them all at once. Same objection as to all of these number 6, Mr.
Yes, Your Honor, it's a bank record from Chevron Valley Credit Union. It requires the authentication.
well, it's in his trial brief also that he submitted too.
Well, just because it's in a trial brief doesn't make it admissible.
Petitioner's exhibit 6, marked for identification.
And she testified to understand about withdrawing the money too into that from the account. And
Not
so
during this trial.
she did it today. She did,
Well, we're focusing, I need that date. The date that you told me that there was an agreement between the parties that these would be admissible. You said you were gonna look at your notes.
right. As
So-
far as you mean when they were lodged, right?
No, when they were subpoenaed in, there should have been an agreement put on the record that the parties would not object to chain of custody.
Okay. So are they bringing over those paper, are those documents?
They're coming right now,
Okay.
but that doesn't change the same question that I had.
When they're lodged, do they go through a chain of custody? Are they stamped?
We'll have to see what happened with them. Not all the time. Not always stamped, they're not always stickered. So, do you have a date for me to look at a minute order that says that there's a stipulation to as to the chain of custody?
Okay, hold on here.
There's people in the back that are talking. It's inappropriate.
Again, ma'am, you can talk during breaks with him, but you can't talk during the proceeding.
Okay. Okay, I believe it was let's see. Around 1/7/19 of 19.
Okay.
Mm-hmm.
Do you have the subpoena that came? I'm gonna read from the January 17th. It says, council stipulated, this is between Mr. Kilpatrick and Mr. Kennedy, to subpoena record be released to Mr. Kennedy, the copy of the return results. It doesn't say within the chain of custody, it doesn't say, it just says copy returned. The language isn't broad enough to encompass the code section, so I have to sustain a hearsay objection. Do you have any other documents?
Yeah, I do, I believe so here. I do have documents here.
So 3, 4, 5, 3, 4, 5.
So you're saying the language doesn't
Sometimes documents are subpoenaed in for the purposes of being put into a hearing later on. Sometimes they're subpoenaed just for the purpose of discovery. When they're subpoenaed just for the purpose of discovery, the council tend not to have specific language identifying the chain of custody. The chain of custody was not identified in this particular minute order, so I'm not going to.
I believe I had it recorded from my notes too. On that date, that they agreed on, and they lodged it.
I have to go with what's before me in the court record.
Huh?
I have to go with what's in the court record before me.
Well, the court records is valid, right? Because it was mistrial, so nothing matters.
No, that's not what that means. It means that we're starting from scratch. But
Right.
for evidentiary issues such as, if it would have said that language, I would have admitted it over Mr. Kilpatrick's objection. But it doesn't have the language.
Well, it's confusing talk because I don't understand what do you mean by starting from scratch, but then you're saying you can use this, you can't use that.
Do you have any other documents?
Well, yeah, I do, but I'm trying to clarify what is it means by starting from scratch.
It means that the documents that you put into evidence,
Uh-huh.
whatever happened at the last hearings, I don't know. But if they agreed to them going to evidence, if they didn't agree, whatever happened, that's set aside. But if an issue such as that you had agreed that chain of custody would go forward, like I said, I would have admitted it over Mr. Kilpatrick's objection. But I'm not admitting them because the proper language isn't there.
I mean, we're basically talking about escrow, subpoena from the escrow company, right? Which are business records, but that's what we're talking about, correct?
That's what we were talking about.
Okay.
Do you have any other?
So I'm submitting the proof that to prove the 2640, we have to prove, that it was my separate property, that the money wasn't transmuted. It was from mine here to this account to there, right? And that's what I'm building the foundation for. So the grant deed, single man, she signed over a transfer saying, hey, it's all his. Now I'm showing you the documents that we subpoenaed from them. I gave you notarized ones showing the escrow company how it went through, and then I gave you the breakdown from the title company. Now, do we need to subpoena again? Is that what we need to do?
I can't give legal advice.
Where he's mistaken, the interspousal transfer deed on July 13th of 2004 is presumptively obtained through undue influence. That's the law. He has to overcome that presumption, and it's virtually impossible.
There was no transmutation. It was not like she was ever added. So there was nothing, and the language is clear on there. It even states in the code from the county that it's clear. The intertransfer spousal, yes, that's on top of her not even being transmuted at any point with that property. I was single. That was separate.
Okay, what other documents do you want me to consider? I made my ruling on them.
Okay, so are we now? What are we? So am I submitting these documents, the ones that are putting in, or what are we doing with them now?
3, 4, 5, and 6 are marked, which means they're, with lack of a better word, they're lodged with the court and they're available for future reference. But I cannot consider them as evidence.
So I can submit them for the truth of the matter, right? I mean, we're not trying to block the fact that that's what it is. It's the facts here, right? Separate property. I mean, I know he's trying to say that it wasn't, but what it is, I still can build a foundation for that to have these relevant evidence to be submitted, right?
Actually, he cannot. He has to obtain a separate property interest in the Sager property is pretty specific and quite difficult. The evidence is clear that the Sager property was acquired on May. I will concede that he purchased the other property on May 15th of 2000. They married on 2001. They sold it in 2004. There's no evidence of a Moore Marsden calculation, which would then lead to what is left over for a potential 2640 claim, and that is his burden. The interspousal transfer deed is presumptively obtained through undue influence, with the legislature overruling Haynes and his progeny and the Philipon case of Moore. And so he's just failed on his burden of proof. He's failed on. I have the math, and I'm ready to make an offer of proof and bring the property part to a close.
Well, he hasn't.
I have the code for the 2640. He's incorrect about that. He's making ruling for us now, or
No,
he's saying that. He sounds like he's telling you what to do. And I don't understand how he said I failed on this, and I did it. What?
If you would have listened to me, I just said you didn't fail on it.
Okay, I'm sorry. I apologize.
Evidence.
Okay.
That's my argument, that there's a failure of proof.
Okay. Well, I'm looking at the Family Code 2640 and what's the requirements for it, and it's pretty straightforward. There
is substantial decisional law that's interpreted 2640 over the years, and it includes interspousal transfer deeds are presumptively obtained through undue influence. They're inadmissible unless you can overcome that presumption. And frankly, I have attempted it many, many times. I don't even try anymore because you just can't do it.
The intertransfer spousal has its own code. It even specifies in the intertransfer. I understand a loan by itself that it would not be, it holds the same weight. But we're talking about a property that was never transmuted. She was never added, took off. It wasn't commingled like that.
We're not at the point of argument, we're at the point of evidence.
Okay.
I'm ready to make an offer of approval of where we are with things whenever Mr. Harkins concluded his case.
Do you have any other evidence you want me to consider?
Yes, and then also, my question is also, okay, the other documents that he objected to, where we stand on that?
The deeds are in evidence, everything else is not.
Okay.
Everything else is marked for record purposes.
So we're gonna go to that next step to have them admitted?
We've already discussed that, and I've already made my ruling as to what's going to be admitted and what's not. Do you have any other documents?
No, I mean, I can have those admitted. They're lodged with the court, right?
Just because they're lodged with the court doesn't mean.
Do I have the opportunity to have them admitted?
I've ruled that's going back to the issue of the chain of custody. Chain of custody wasn't properly made. I can't admit them.
If they're stamped and they're marked on those there, is that the chain of custody there?
No, it has.
They're sealed?
Because that's a separate issue. Once the, I don't know where these documents, I wasn't present for their admission.
That's what being lodged though and sealed, and I mean, if they're stamped, they should be marked.
Do you have a, can you pull out the exhibit list? Just the list itself. Or if you have to take it apart, just. Okay, there was in front of Judge Green, there were 4 marked exhibits. They were the following petitioner's exhibits were identified. There was a 53-page document, declaration of records of custodian, that were identified but not put into evidence. So Judge Green did put them in evidence. I can't consider them in evidence today without proper foundation. There was a 4-page document, a grant deed, which I believe is in evidence that I have before me today. There was a three-page First American Title insurance company, which I believe are 3, 4, and 5 that actually were in evidence, but you haven't laid the foundation for today's purposes.
I can lay the foundation for them.
Do you work for First American Title?
It's personal. I have personal knowledge of the document. I've signed them. I can lay the foundation.
Mr. Kilpatrick?
He absolutely cannot lay
That's
the
incorrect.
foundation for bank records, business records. Evidence Code Section 1271 requires the custodian of records of that business and or financial institution to lay that foundation thereon.
The grant deed, and I made my ruling on that, the grant deed was not put into evidence. The interspousal transfer deed was not put into evidence. It hasn't been put into, last time it was not put into evidence. It is in evidence this time. Letter from Kern County Department of Human Services, no idea what that is, I haven't seen it, it's not.
Probably a CPS.
Yeah,
So-
CPS.
So to answer your question, it doesn't appear as though chain of custody was laid at the last hearing on most of these documents.
It was though.
Not according to the record. Anything else?
Well, the record doesn't matter if it's been mistrialed, right?
Well, you were asking me to rely on the record. I was looking at it.
And I still have the option to lay the foundation for these documents, right? And they're relevant documents to prove my case. I have the right. It's in my trial brief that you said that we're going off of because we didn't introduce new trial briefs. You said we're going to basically use the ones that we had already laid them. Well, I have the trial brief right here that states in here what these documents are and what their amounts are, and I can have the ability to lay the foundation on the record. Yes.
He does not, he cannot lay the foundation for
Yeah,
that. Only
how's-
custodian
how-
records for the business or financial institution.
Not laying it for the business.
Do you work-
1271.
Do you work for First American Title?
Your Honor, I don't have to work for First American Title to lay. These are these are documents that I have personal knowledge of. These are my escrow documents. I have signed. I know them. They are in my personal possession. I have also my copies of them, let alone the ones we subpoenaed.
How are the records stored?
How are they stored?
Yeah, how does First American Title store the records?
Electronically.
And what's the name of the system that they use?
The name of their system?
Yes, the name of their system.
Well, back when they were First American, when I was probably using them, I don't know if they still use the same system or not, but I mean.
Well, if you don't know, then you can't lay the foundation for the.
But I don't know why the document can be offered for the proof of what it is, though. I have personal knowledge of the document. I don't know why you're blocking me from this. I know why you're doing it, but I mean, the document is authenticated. I can prove that. So. Hey, give them a name. That's what they're doing. It's all right. It's all on the record. It's all right. It's all right. It's all right. If they have a civil case against them, you're pretty quick. I'll be filing a civil case against you. You'll be getting it. Don't worry. All your life, you're coming out. Dirty hands. It's all right. Mm-hmm. You want to play games? I know. Yeah. Green told me that. So they're just trying to change it up. I have that recording too. And Green told me that. See, you're gonna catch me on a lie, watch. Hmm? No, just forward that. I'll find out. They don't play that route. Hmm? You can try. That's hella illegal right there. He doesn't know what to do, see?
record, Hartman versus Hartman. So the first question of the new business record entry is that person custodian a record for someone that works for the company, that's familiar with the records, that will be able to testify as to how those records are stored, produced, and the nature and how we know that they're trustworthy. Mr. Hartman doesn't work for any of these entities that may or ruin anything else on the issue of property.
Well, are you saying that because I don't work for title company that the subpoena? So let me get this straight. We did all the process. Green mistrials this case, and you're saying after they were lodged with the court and sealed and agreed upon, you're saying now they're not valid, right?
That's not what I'm saying.
You're saying they.
I've stated my position.
Okay, you didn't state your position clearly though to me.
Do you have anything else that you?
I do. The documents with the court, also on the trial brief too. We're going off the trial brief, right?
Trial briefs are just designed to show
Right.
or what you anticipate they are not evidence.
You ordered them though. You
themselves.
ordered us to use the ones that we've already had submitted.
Do you want me to refer to a trial brief for some reason?
Right. I do because they have the figures are in there.
Trial briefs are not evidence.
The trial brief is not in evidence.
Is he making ruling for you, or I mean, every time he says something, it's law?
Mr. Patrick is appropriately quoting the law.
Is he now?
He in fact is.
Okay. Well, most of the time he's been incorrect. Is what his statement has been.
I never.
He's been making a lot of errors there, and
Never make errors.
of course he doesn't.
Okay.
So the documents that have been lodged, do we get those documents back? Can we resubmit them? Because there's other documents in there that I can lay the foundation for, right? That are in the trial brief that we're using, that were ordered by you to use. So I can lay the proper foundation for those, right?
Okay. Mr. Kilpatrick, I'm turning to you now.
Yes, thank you. I will make my argument on the real estate by way of an offer of proof. My client would testify to the following. The current fair market value of the Sager property is $350,000.
Okay, Mr. Kilpatrick, I'm going to stop you there. I want you to have her testify.
Very well. Then please will you take the witness stand? You're still under oath, Ms. Hartman. What is your opinion as the current fair market value of the Sager property?
$350,000.
Is there currently owed $51,064?
Yes.
I know you can't do the math in your head, but by simple math, there's an equity position currently of $298,936. Is that correct?
Yes.
You want your half of that equity or $149,000?
Objection, Your Honor. He's telling her these numbers. What is it? He's leading this witness.
I've sustained that objection. Go ahead and ask.
$298,936. What is that amount divided by 2? Do you need to use your calculator? I'd like her to use her phone.
She can use your calculator.
Sure.
So divide $298,936 by 2. What is that?
Can't find my calculator.
Say that number one more time, Mr.
$298,936.
168?
It would be $298,936,000, $298,936.
Objection. Where is he getting these numbers from?
Divided by 2.
Yes.
Mr. Kilpatrick, where are the numbers coming from?
Or let's just start over again. You believe the property is worth $350,000, is that correct?
Correct.
And you owe, and the current mortgage is $51,064?
Correct.
If you would take $350,000 minus $51,064, what does that equal?
I have $318,936.
$350,000
Okay.
minus $51,064.
$350,000.
Minus 51064.
5064. $298,936.
And if you divide that sum by 2, what does that equal?
$149,468.
You're requesting that you receive that half of the equity out of the property, is that true?
Yes.
You're also requesting what is commonly referred to a watch charge, or 1/2 of the fair rental value of the property since separation, is that true?
Yes.
What is your opinion as to the fair rental value of the property?
Probably 2,000.
2,000 a month? And what is the current mortgage?
381.89.
So would you take 2,000 minus 331, we'll just round it up to 332. What does that equal?
1,668.
And you and Mr. Hartman separated January 6th of 2015, is that correct?
Yes.
And there have been, and as of January of 2022, 8 years have elapsed, is that true?
True.
Could you tell us 8 times, what is it, the sum of 96 months times $1,668?
Okay. 96 times, say it again?
96, take 96 times the $1,600. 96 months times the difference between 2,000 and the mortgage. What does that sum equal?
Which was 1,600 and
Right. It was $1,618
$6,018.
times 96. And what does that equal?
Equals 155,328.
And if you divided that by 2, what do you get?
77,664.
And you're requesting that sum be awarded to you as 1/2 of the fair rental value pursuant to the opinion out of the 5th District Court of Appeal in re the Marriage of Watts.
Correct.
So do you have an objection to Mr. Hartman, assuming he can accomplish within 30 to 60 days from today's date?
Objection, Your Honor. You can't use, Mr. Kennedy explained to Mr. Kilpatrick in the beginning, you can't use just Watts charges without the Epstein, credits. They go together. You tried to do this before, and Gil already corrected him on it.
I'm going to turn to you for discussion.
Judge Gil corrected him on it.
So you're asking that if he wants to refinance the property, that he pay you your 1/2 of the equity of $149,468, correct?
Correct.
Plus the watch charges at $77,664. What do those two equal? 149,468 plus 77,664.
149,168.
468.
I'm sorry.
149,468
149,468
plus 77,664.
77,664. 227,132.
So you're requesting if you refinance, you pay that sum by using the 80,000 we're holding in trust, and he refinance the difference and pay that $227,132 to you within 60 days.
Correct.
And if he's unable to do that, are you asking the House?
Objection, Your Honor. I'm objecting because these numbers that he's coming up with, he cannot use Watts charges without Epstein's credit.
I told you I'm going to ask you about Epstein credits in a moment.
Okay, all right, but I mean, he's making.
And I haven't ruled in his favor.
So you have it.
Okay.
So you're requesting $227,132 be delivered to you within 60 days, and he can use the 80,000 in trust as part of that. You're okay with that?
Correct.
And if he cannot, or is either unable or unwilling, that the property be sold and the proceeds be divided, correct?
Correct.
And from his share, the Watts credits of $77,664 be awarded to you.
Correct.
And that takes care of the house.
Correct.
No other issues, no other evidence on the house.
Any other property?
There is a travel trailer, is that correct? And
Correct.
who
And a
has
mobile
possession
home.
of- Who has possession of the travel trailer?
He does.
And when did that travel trailer be acquired?
During the marriage, I don't recall the exact year.
What do you think it's worth today? Just your best estimate.
Maybe 7,000?
And you're requesting that be awarded to him at $7,000. And pay you $3,500 to make it right. In
Objection.
addition to the other monies. Is that true?
True.
No other evidence on property?
Okay. Sir, do you have any questions on
I
property?
do. I do. Okay, you left the house, in 2015?
Yeah,
You cleaned our savings account out a week after you left the house?
I did a withdrawal.
You did a withdrawal. Okay, what was the amount of withdrawal that you took out of our account?
I think it was 15.
1,500, 15,000?
Thousand.
And he gets a credit for that. I said, we don't.
I didn't hear that part in
We
there.
can see that he's entitled to a credit of
Anyways,
$15,000.
I'm not finished, but,
$7,500.
okay. So you left the house 2015, you cleaned the bank account out a week later, which was the sum of, 16,000. You haven't been back to the house since, have you?
No,
Okay. Have you made any payments towards any of the marital bills, assets? Have you made a payment towards the trailer, the house, the mobile home? Any of that? Did you pay the property taxes on the house for 8 years? Do you do any maintenance on the house at all
no.
since you left? Okay. So Mr. Patrick's figured you guys got your hand out saying, hey, this house is worth this, you got equity, man, your house payment's really low. This is what the fair market value is. Well, that payment is low because of why? Because I put my separate
Jack,
property down
this is not
to
a
get it
question.
low that way.
This is not.
I bought the house down.
This is
I'm
not a
going to be
question.
able to testify to that. I'm going to give you a moment to testify about that, but you don't, but you're not asking her a question.
Okay, I apologize.
Sorry, Mr. Kilpatrick, I cut you off. I didn't hear what you had to say.
That's not a question. He's not asking a question.
I'll rephrase. So in 2015, you left, you took the bank, which was about 16,000. You haven't made a payment on any of our marital bills for 8 years.
Correct.
You haven't made any maintenance either. You haven't fixed anything. You didn't do anything towards the properties. Nothing. Nothing at all, have you?
Correct.
Okay. You're currently working right now?
Yes.
What did you do with the savings?
It's irrelevant.
You're getting half of it, or you're getting $15,000, correct?
He gets a $15,000 credit or $7,500 because that was withdrawn from the bank.
Because half of it was yours.
Okay. As far as the toy hauler, he's putting the value on it just out of the air. I've been making the payment on that toy hauler for the last 8 years by myself, and
Then you can ask for Epstein credits when it's your turn to testify about it. Anything else?
the mobile home, also same thing. Made payments on the mobile home before it was sold, which is, the amount that was the profit that comes off the top of that. I had to pull it. I have evidence for that mobile home showing that I put my separate property to pull it out of foreclosure, and
Is that Sandra Drive? Right, I'm confused. We mentioned Cedar, we mentioned Sandra Drive.
it's State
We
Street.
mentioned, this is the first I've heard of a mobile home.
No, it's in the trial brief and it's been in the record.
Any evidence today, this is the first I've heard of a mobile home.
Huh. I don't know why he's not talking about it, because he's got the escrow check in his account.
Mr. Kilpatrick.
I don't have an escrow. I have a check of $80,000 that Judge Gill ordered him to pay as a condition to setting aside the judgment. And it remains in a separate account at Wells Fargo Bank, and it's accumulated a small amount of interest over the years.
That's incorrect. He's got $85,000. That was a stipulation to get the judgment set aside.
Correct. I still
Okay,
have.
the mobile home was sold, and the money from that was a check for $55,000, which was put into an escrow, trust account that Kennedy had. Both those checks were sent over to him, and he took me off of that, which is the $85,500 was a loan I had to get to secure to get the judgment. So, but you took my name off of it. I don't know how you do that when the trust, but
Your name is.
it was on there. That's my separate property.
Okay.
Gil maybe acquired that to get a judgment, to get my judgment.
It is in a separate segregated
Okay.
interest-bearing trust account.
With the mobile home, with the money from the mobile home?
I can't speak to that because I'm not aware of that.
You're not aware of the mobile home money?
I'm not aware of the mobile home money.
Okay.
Everyone back tomorrow, 1:30.
Thank you.